But I'm going to tell you right now, listeners, buckle in on this one because we are all going to get schooled. This is going to be a fascinating hour. If you have been following Rittenhouse trial at all, which I have, lock, stock, and barrel from beginning to end, as much as I can get in before doing what I do now on The Daily Show. And Andrew Branca, one of the best attorneys in the country, wrote the book, The Law of Self-Defense. You've heard him on the show over the years. Andrew, let's go to you now. And I've been sitting here waiting for this conversation all week long. How you doing, my friend?
I'm living the dream, man. How are you doing?
I'm doing great, and you are living the dream. And I want to let listeners know you can see The Law of Self-Defense as a partner with Armed American Radio. His book is up there on the show, or on the website. You can click on it, and it'll take you right over to Law of Self-Defense. And I want you to do that. But what you're getting ready to hear this hour, you'll understand why. So give yourself the hour. And like I said, grab a beverage, grab some popcorn. Let's get going. Andrew, I have no notes in front of me. So we're literally just going to take off from square one. So let me start with this. We are on the eve of the closing arguments, which will occur tomorrow, 2.5 hours for defense, 2.5 hours for prosecution, correct?
Correct. Yes.
Should he have even been charged based on everything you've seen? Should he have been charged at all? And what were the dynamics that went into him being charged, do you think, as an expert in this?
No, there's no legal basis for charging him. Certainly at the time they charged him, there certainly wasn't. And frankly, I don't think so, even if you believe this 11th hour discovery of evidence by the prosecution that was, I guess, left for him by the evidence fairy on his doorstep last Friday. Even then, I don't see any grounds for prosecuting this poor kid who was, tremendously, how can you say it, abused by being seriously assaulted with murderous attacks by grown adults in the midst of a riot, successfully defended himself against all of them, suffers PTSD now from the experience. And as far as I'm concerned, he's simply being subject to abuse again by this prosecutor and by the criminal justice system for no good reason.
You see, that's fascinating. And tell me if you think I'm wrong or right here. And I think you and I have talked about this off the air, but when I look at social media, which I hate to do, I hate the pseudo-intellectual idiot psychobabble or conversations going on over there, but it's fun to read, if not just for that, so we can have conversations like this about those idiots. I believe it's a fair debate to question on the outset whether or not he should have been there. That's a fair debate, right?
Absolutely.
All right, where does that come into play in the trial?
Well, it really doesn't. If I had I have children, some of them grown. My 17-year-old son ever came to me and said, "Hey, Dad, I'm going to take an AR, go hang out in the midst of a riot, and arson and looting." I tell him he was out of his mind because that's not a prudent thing to do. It's not safe to do that. It's dangerous to do that. And I wouldn't want my children engaging in unnecessary, dangerous activity. It's poor judgment. But poor judgment is not a crime. And he's not being prosecuted for the crime of poor judgment. He's being prosecuted for having used force in self-defense to protect his own life from murderous attack. And those are two completely different things. We all engage in poor judgment from time to time. That doesn't mean we should be on trial for murder if someone attacks us. So from the basis that I'm trying to lay down here is that because that wipes out all the pseudo-intellectual psychobabble right there. It all goes right out the window. But it's fair. You can argue whether or not he should have been there. And I've used the same example on this program. I have a 17-year-old son. If my son came to me, and I'm quoting myself from months back now, what are we, 15 months out from when the incident occurred? I said on this program and The Daily Show, Andrew, the same thing you said. If my son came to me and said, "Hey, Dad, I want to take one of your AR-15s, I'm going to the riots." Well, the answer to that would be a whopping no, you're not going to the riots. But he was there. And the fact that he was there, was he there illegally? Not unless you count the curfew violation, which is only a ticketing offense. In fact, they dropped that charge completely. So I don't think anybody takes that seriously. Obviously, there were thousands of people walking all over the city past a curfew. The police were doing nothing to enforce it. For all practical purposes, it wasn't in effect. Other than that, another way to put it would be he has had as much a right to be there as anybody else. And all those other people were there. So again, imprudent decisions, but imprudent decisions are simply not crimes. I mean, the only rationale for bringing this prosecution is purely political. That there are people, not everyone thinks these rioters are bad people. They get protected by certain segments of society. Some of those people are in high positions of power. I mean, mayors, prosecutors, police chiefs, they don't pursue these people with the aggressiveness that you might think you would pursue people who are burning your city down and looting the businesses and terrifying the public and seizing control of blocks of your jurisdiction. They don't seem to do anything about it. They're sympathetic to these rioters, these looters, these arsonists. They're on the same team mentally, emotionally.
There you go.
So when you shoot them, you shoot the rioters, looters, and arsonists. As far as these people in authority, some of them are concerned, you're shooting members of their team. And they don't like that. And they'll make you pay for it. And by the way, if it was poor judgment to go to Kenosha during those riots, and it was, even if he's acquitted, Kyle Rittenhouse is paying an enormously high price for that act of poor judgment. He's paying the price for it.
Andrew, before we go to a break, wasn't it poor judgment for the three individuals who were shot to go to the riots, or anybody? Because certainly rioters, you won't hear this on the legacy media, but certainly some of those rioters crossed state lines with their guns too. In fact, some of them were felons in possession of guns. Isn't that imprudent as well?
Sure, but they're on the same team as the prosecutor, so the prosecutor is not going.
Go.
I mean, one of the actors involved in this scenario, this Joshua Zeminski, has been charged by the prosecutor with an arson charge. As far as I'm concerned, he was only charged to put him on ice, so he would not be available to testify in this trial because his testimony would have been harmful to the state. So you charge him. If he gets called to testify, he pleads the Fifth Amendment. He can't be compelled to testify. I think as soon as this trial is over, those arson charges go away.
Interesting stuff. It's kind of hard to believe that a prosecutor who lost his bid last year and might want to run again would do something so dirty simply for political reasons. As I said, buckle in. We're going to start getting into the meat of the trial now. You probably saw it last week. Now we're going to talk about it. Andrew Branca, The Law of Self-Defense. We'll be right back. I wrote a piece over at Armed American News where I talked specifically about what Andrew just mentioned. And because of that, let me give you a little bit of insight, which will lead to some questions for Mr. Branca. And that is that, to me, the liberal mind has been so conditioned by the elitist leftists and the constant drumbeat of liberal propaganda, which reinforces a victim mentality, which is what Andrew was talking about, that mind is incapable of understanding the concept of self-defense, particularly when the obvious aggressors, the rioters, in their minds are the real victims. Taking case in point, which you just heard from Andrew, the victims are on the same team as the prosecutors. Rittenhouse isn't a victim because he wasn't rioting. The rioters are the oppressed victims. That's why they're rioting in the minds of a liberal. It's why they get a pass from the mainstream media, and it's why anybody opposing them is seen as the oppressor. They're the victims of anyone who doesn't agree with whatever is keeping them oppressed, and it's why those caught burning, stealing, looting, for example, walk with no charges. They're viewed as righteous. In their minds, for that reason, they will never, ever, ever understand that Kyle Rittenhouse acted in self-defense. Andrew Branca, is that a true statement?
Well, I mean, my expertise is the law, not politics. What I can tell you is when I look at the facts of this case, the evidence in this case, in light of the self-defense and criminal laws that apply to those facts, there's simply no reason to believe within any degree of legal certainty that a fair and impartial jury would return guilty verdicts on any of these charges. The prosecution has to disprove self-defense beyond a reasonable doubt. And he's so far from that it's laughable. I mean, the Rittenhouse narrative on defense on each of those use of force charges is overwhelmingly in favor of the defense. And that's why the prosecution has pulled this provocation allegation out of the blue at the 11th hour, because if they can prove provocation beyond a reasonable doubt to the satisfaction of the jury, then all the self-defense stuff doesn't matter because you just don't qualify for self-defense if you're the unlawful provoker of the confrontation. So if you look at the chessboard for self-defense, all the pieces are placed in favor of Kyle Rittenhouse. What the prosecutor is doing with this provocation allegation is tipping over the chessboard, dumping all those pieces on the ground and saying, all right, we're starting new. We're claiming that you provoked the confrontation, and therefore you simply don't get to argue self-defense. Or you can argue it, but you don't qualify for it under our narrative of guilt.
I hate to ask you this because we never know what a judge or jury is going to do, but what are the odds that he's successful with that? Because anybody that watched the trial witnessed exactly what you just said, that he's trying to say if you weren't provoking him or them, they wouldn't have attacked you. That seems to be the line of logic. Am I right there?
Yes, and people need to be careful because I'm using provoking in a very specific legal sense here. It's
okay.
not. It's people think of provocative behavior. It comes in an infinite number of forms. People can be provocative in a lot of different ways. But for our purposes, when we're talking about these use of force events, we actually first start with some forcible reaction from the person who might have been provoked. So here we're looking at Rosenbaum, the first gentleman who was shot by Kyle Rittenhouse. His pursuing and fighting Kyle for control of Kyle's rifle. That act, that forcible act by by Rosenbaum. Once you've identified that, the next question is, well, did Kyle provoke that? Did Kyle do something that resulted in that act of violence? Because people do provocative things all the time, but if there's not a violent response, the provocation doesn't matter, legally speaking. So we only care about things that resulted in an immediate violent response. And here at the 9th hour, the 11th hour, I guess I should say, the prosecutor suddenly claims to have video evidence of Kyle pointing his rifle at someone near Joseph Rosenbaum and claiming that angered Joseph Rosenbaum enough that you got a violent response as a reaction to Kyle's provocation of pointing the rifle. Frankly, if any of us who look at that imagery, that supposed imagery of Kyle pointing a rifle, I don't see it. And I've looked at it a lot on a 4K iMac desktop monitor, zoomed in, zoomed out, slowed down, speeded up. I just don't see what the prosecution claims to see in that image. I don't think the jury will see it either, unless they want to see it. People will see things they want to see. And I think that's the real risk here. It's not that the prosecutor, I don't think even he believes he can convince 12 jurors unanimously beyond a reasonable doubt that Kyle Rittenhouse pointed his rifle and provoked an attack on himself. I think what he's hoping to do is find the interested juror, the juror who may not be willing to convict on no basis at all, send someone to prison for the rest of their life on no basis, but they wouldn't need much of a basis because they're on the opposite team. So they only need a little bit, a thread offered to them, and they'd be willing to vote guilty. And this may be that thread. Now, you won't get 12 jurors like that, but you might get one. And if you get one, you don't get an acquittal. You get a hung jury, you get a mistrial, and the prosecutor gets to do it all again, which for him is fine. He's in court anyway. That's his normal day job. And of course, this is obviously a personal mission for him. But for Kyle Rittenhouse, a mistrial is a disaster. It means he goes through the whole process again, but with much fewer resources. I mean, whatever resources he started this trial with, he burned through a bunch of them. You don't start over again with the same money. Your lawyer still got paid for the first trial. So every time there's a retrial, you're starting that new battle with fewer resources than you brought to the last battle. And you didn't win the last battle if you're in this one.
And let's face facts, too. At some point in time, public interest is going to begin to wane. And the media is going to go in another direction. They'll continue to cover it, but not to the degree that they're covering it now if you go through 2 and 3 trials. So that doesn't help Rittenhouse's case. Let me ask you this. Is having the gun itself a provocation? Is that what they're trying to use?
No, not even the prosecution is arguing that. In fact, during the what they call the instruction conference, the meeting that the lawyers have with the judge to decide what the final jury instructions should be, the prosecution explicitly said that's not the argument we intend to make at closing. That merely being present with the rifle was I think they might have tried that if they didn't come up with this nonsense picture. You know, now they feel they have something better. But they're saying now that no, we never intended. By the way, it's worth noting that if you were to go back and look at the opening statement by the prosecution, where they tell the jury, this is the stuff we're going to prove. This is our theory of the case. This is what we think happened, and this is why you should convict. They mention provocation 0 times. 0 times.
0 times. Andrew, we're getting ready to take a break. When we come back, let's go back to that. And then I want to ask you specifically about some witnesses, and mainly Grosskreutz, who seem to make the defense's case as a prosecution witness. We'll get some expert advice on this and some insight from Andrew Branca. Fascinating stuff. Armed American Radio's Monster Cast. All of it presented by X Insurance. Continues right after this. More of our sponsors coming up later in the show. Let's go back to Andrew Branca, The Law of Self-Defense. Andrew, before we go any farther, tell people where they can get your book and join you over there, listen to you, and read all of your fascinating work.
Yeah, sure. People can actually get a copy of the book for free. It's a $25 book on Amazon, plus shipping and handling. We provide the book for free to anybody who wants it. We do ask you to pay the shipping and handling to get the book in your hot little hands. But you can get that at lawofselfdefense.com/free book. It's a real book, folks. It's a physical book. We mail it to you. It's not just an ebook or something like that, a couple 100 pages long. And it's a plain English guide to how self-defense law actually works. If you want to go to Amazon, look at the reviews. We have, I think, 1,000 reviews, solid 5-star ratings. So that's just to validate the quality of what we're offering. But I wouldn't buy it on Amazon. I would just go to lawofselfdefense.com/free book for the book. And of course, you can find us on YouTube and Twitter and, on Mark's show from time to time.
Yeah, and I'll tell you, Andrew's book is a Bible at my house. It's marked up because I've used it for so many references over the years. And the additions, just like John Lott's work is, it looks like a textbook at my house, but it is a staple here in the Armed American Radio studios. And getting it for free and paying the shipping, it's a no-brainer. Thanks, Andrew, for that information. Let's move now to some witnesses. Let's go specifically to Grosskreutz. I was absolutely blown away when I saw the defense questioning Grosskreutz. He's the one that had his bicep obliterated, or as he said in his own words, vaporized. And he admitted that he had his hands up, that when he was 5 feet away, the rifle was not pointed at him. He did not, I'm talking, of course, about Rittenhouse, did not fire on him. And he admitted in court that it wasn't until he pointed his handgun at Rittenhouse that he was shot. And if I'm a prosecutor at that point, I'm pulling my hair out of my head and trying to avoid the camera to do it. Did he not help slam dunk the defense, the defense's self-defense case here with statements like that? It would seem so.
It was pretty ugly for the prosecution for sure. But here's the thing. When we get to closing arguments, the prosecution is going to talk for 2.5 hours about why the jury should convict Kyle Rittenhouse on every one of these charges. And he's only going to mention the evidence, the testimony that's favorable to his position. So, and he gets to talk first. So I would expect the prosecutor, the first 2 hours of closing, the jury's going to be hearing a narrative of guilt supported by cherry-picked pieces of the evidence from the week and a half of testimony that we had in that case. And if you can just cherry-pick things out, well, it sounds good. It sounds like a compelling argument. What a wonderful narrative there. I'm convinced. Then you have to hope, if you're the defendant, that your defense counsel can do just as good a job picking the specific pieces of the evidence, of the testimony, that will counter that narrative of guilt, that will sustain a reasonable belief, hopefully an outright claim of self-defense justification, and blowing up this ridiculous provocation argument. And that's the job of the defense. And you hope the defense is going to do a good job, but you never really know until they're in the arena actually doing it. I mean, I can tell you, I've seen plenty of closings where either it looked good for guilty or good for an acquittal, and then the closing was a train wreck. And all those predictions go out the window. So we don't really know, but there's plenty. This prosecutor, this assistant DA Binger, Thomas Binger, the lead prosecutor on this case, you may think he's contemptible, and I think there's good reason for that, but he's not stupid. He's smart, and he's a smart lawyer, and he knows how to pull the legal levers to advance his narrative of guilt. Whether he can be sufficiently clever in doing that to convince this jury, whether the jury is particularly amenable to buying what he's selling, is difficult to predict. One shortcoming we all have, and I've watched every minute of this trial and every minute of the pretrial hearings, But we don't get to see the jury, right? We don't get to see their faces, how they're reacting to these arguments. And the lawyers do. So hopefully the lawyers are crafting their arguments to make them as sellable to these jurors as possible.
Yeah, I have to assume that the jurors, though, are smart enough to say, hey, we just got played. He didn't mention this, because they did see it. They did hear it. But you're right. You never know. And now, is it an advantage to the defense to come after the prosecution in closing?
Well, the way it works is the prosecution goes first, and both sides, they each have 2.5 hours, which is frankly a crazy amount of time. But, and I think to the disadvantage of the defense, frankly, because Thomas Binger, the prosecutor, he likes to talk. He's extremely verbose, and he just gets repetitious and starts saying the same things over and over again in kind of a loop. But that loop approach can be effective with people. I mean, you present it as if you're saying something new. You're really not, but it sounds like it's new. It sounds, if you say, right. One of the things they did with this ridiculous drone video and photographs they pulled from it is now they're saying, hey, it's not just the drone video. We have the drone video. We have the photos from the drone video. We have the detective's testimony about the drone video, as if those were 3 different pieces of evidence. It's all the drone video. You know what I'm saying? Right. But they present it in such a way that the jury feels like, oh, it's not one thing, it's 3 things or 5 things or 10 things. But it's really all the same thing. They have a slowed down version of the drone video and an enhanced version of the drone video. And they present it as if these are all distinct pieces of evidence that reinforce each other. It's all the same garbage piece of evidence, but they're clever in how they present this stuff. I mean, that's, folks, and you never know how amenable the jury is going to be to buy that line. And that's why I always caution people. You know, you always hear people say, well, I'd rather be tried by 12 than carried by 6. And I feel like, well, you've never been a defendant in a criminal trial, because you don't know what those 12 people are going to do. And don't assume they're normal, fair, and impartial people.
Never know. Never know what a jury's going to do. And let's keep this in mind, too, as we go to this break. When I come back, I'll ask about Rittenhouse's testimony himself. But there are people in Kenosha that are sympathetic to the rioters. They keep electing the mayors. We'll be back right after this. Andrew Branca, don't go away. Andrew Branca, Law of Self-Defense. Let's move to Rittenhouse now in the final segment of the hour. I want to apologize for time going so fast. I wish I could do something about it, but I can't. Let's talk about Rittenhouse. First, would you, watching everything from pretrial through everything that you've seen, would you have put Kyle on the stand as his defense attorney?
Well, this is one of those difficulties that arise because we can't see the jurors' faces, right? So the normal rule in criminal defense is you never put your client on the stand, but the normal client in criminal defense is a dirtbag criminal. I mean, that's the nature of being a criminal defense attorney. Most of your clients are criminals. They have long criminal histories, all of which would come out if you put them on the stand, because then they're just a witness like anybody else, and they can be impeached by a bad criminal history just like any other witness. So normally you can't put your client on the stand. I mean, they would be destroyed if only by their past bad acts, bad convictions, and so forth. It's a little different when you have a good guy case of self-defense, when you have a client who doesn't have that kind of negative history. So that's not a vulnerability for them. There are still, however, really big vulnerabilities. One is, no matter how innocent the client might be, and listen, it's harder to get more innocent than Kyle Rittenhouse. I mean, before this event occurred, I think the most serious thing he'd ever done wrong was drive with his license suspended. So there's, which by the way, the prosecutor brought up, of course. But there's nothing really on him. But you still have the risk that he could break on the witness stand. I don't mean break like he broke down emotionally on the witness stand. That's perfectly understandable. But prosecutors know that if they can get that witness, that defendant, to have an angry outburst, well, that's going to look very bad, especially in the use of force case, right? Because it looks like you're angry, unreasonable. And the prosecutor also knows the specific words he would like to come out of your mouth that he wants to use at closing. Even the defendant said these 3 words. And of course, they'll be taken completely out of context. But in fact, you did say them. So now he's allowed to say during closing that you said those words. It's like when they do these comedic clips where they take words from somebody's audio book and they have them say outrageous things by stitching different words from different sentences together. Prosecutors can do that kind of thing. If you don't take the stand, There's no statements from you to stitch together. You take the stand. And by the way, he was cross-examined, Rittenhouse was, by Binger for over 3 hours. You think Binger doesn't have a transcript of every word that Rittenhouse said that he can scroll through on a computer, do search finds for, to pick out the specific little phrase? He'll hold up a piece of paper in front of the jury during closing and saying, and this client said this, and repeat the exact words. And it's true. He said them. But normally stripped of context to make them, of course, look as negative as possible. So we're going to see a lot of that. So that was unavoidable. The question is, given the relatively low risk, not zero risk, but the relatively low risk of putting Kyle on the stand, was it still worth it? I mean, what did they get? What did the defense get out of putting Kyle on the stand? I don't think they got anything substantive. I think everything really Kyle had to say is kind of in the record already. I think the only possible benefit was the emotional impact on the jury of hearing this kid recount how horrific this experience was. And it may be that there were members of the jury who they might have felt were, not yet convinced by what they had heard previously from the defense. And so this would be the most compelling thing they could put on the table. If I could see the change in the jurors' faces as they heard Kyle's testimony in a positive direction for the defense, then I'd say, well, that was worth it. That was worth the risk. But not knowing that, you always have to wonder if the juice is worth the squeeze, if the risk was worth whatever benefit they thought they would get.
How do you think he did?
I think he did fine. He's an 18-year-old kid. How good is he going to do against a professional, a very experienced criminal prosecutor? But I don't think he
seemed cool as a cucumber, my friend. He really did.
Oh, I'll tell you, I've seen grown men.
He seemed more advanced beyond his years. He seemed beyond his years. I'm sorry. Go ahead.
Yeah. No, I was going to say I've seen very experienced, capable, well-paid businessmen in their 50s break down under cross-examination by a prosecutor like Binger, like they were little babies, and that certainly didn't happen here. No, I think he did a fine job. I don't have any great criticism of how he conducted himself on the witness stand. I'm just not sure it was worth the risk, because it could have gone bad. I mean, it could have gone really bad.
It could have gone way bad. Yeah, it's interesting. Those of us outside the realm of what you do, we always tend to think, man, I'm innocent. I didn't do anything wrong. You better put me on the stand. But you lay it out as to why. Greg has a question from Dallas. Greg, producer, go ahead.
Hey, Andrew. I have, after watching this, I've seen a couple of instances where the judge really admonished Binger, and there were rumors, if not threats, of potentially a mistrial with prejudice to be labeled on this case so that they couldn't come back and try him again. Do you think that might be a possibility before all is said and done? Because Binger did attack his post-arrest silence, and that seemed to be something of contempt from the judge.
Yeah, it was really an outrageous thing for Binger to do. As the judge pointed out, you know better. I mean, any attorney knows better. You're not allowed to do that. But I think the prospects of a mistrial with prejudice now are zero. If the judge was inclined to do that, he would have done it then. He would have had a hearing and said, listen, you mentioned you spoke about his silence. You're not allowed to do that. I want to hear arguments from the defense and from the state on whether or not I should dismiss this case as a mistrial with prejudice. And he would have had a hearing and then made a decision. None of that happened. So clearly he's decided not to move forward on this.
I'm going to ask you two quick questions. We need really quick answers because we've only got 50 seconds. I could keep going with you. Does Rittenhouse walk?
I don't predict outcomes.
Okay.
He should
walk.
To
ask, though. I had to ask.
He should walk.
Of course, he should walk.
Yeah.
And the next question, how long do you feel the jury will be out on this? Any way to guess?
Well, I think if they're not back within 24 hours, it's probably a pretty good chance that we're looking at a conviction on something.
A conviction on something. Andrew Branca, The Law of Self-Defense. Utterly fascinating. Thank you so much for bringing your expertise to Armed American Radio. And I know how busy you've been, and I know the opportunities you've had to do a ton of media, and I appreciate you being here. We'll talk during the week. Andrew Branca, thelawofselfdefense.com. Make sure to pick up the book for nothing. Pay that shipping. Believe me, it's worth it. Just like you heard here.